And good evening, and welcome to tonight's Order Paper Show. Towards my, was it left? Is Chris Norton, a candidate who, for the Greens, who stood in Rimutaka electorate, and independent candidate stood for Hutt City Council at the last local body elections. And, well, we all know with our two favourite people coming from that lovely place in Mike Butterick's electorate called Ekatahuna, Laura and Biggie. How is everyone this evening?
I've got my emotional support cat, so I'm ready.
I think the emotional support cat's probably thinking, what the hell's going on?
What is going on? Come on, I'll let you go.
And
I'll have dinner ready after this. I'm good. I'll have dinner ready after this. So, yep, should be good.
I gave it the crock pot by the sounds of it. It's cooking away.
Yes. But then again, I've spent the afternoon wading my way through Justice Select Committee videos and things. So, yeah, I'm ready for dinner.
Oh, well, that's a bit better than me, who was sorting out council funding applications for the Newtown Residents Association grant and having to get my predecessor to file it, as she's still the one that's still got all the logins at the moment.
Yes, community service funding applications. It was a full-time job.
Oh, I know. I don't know how. Okay, let's kick off to see what everyone here is watching for. Don Brash.
Okay. Bring him on.
Now, can we adjust the? Okay. Bunch of MPs who look like they're trying to get things on there. Jamie Arbuckle must be coming off a smartphone.
Can you hear and see me, Mr. Chairman?
Dr. Brash, good morning. I can hear you. Are we expecting Stephen as well?
Actually, it'll be Bridget Moulton, also from Frank's Ogilvy. Yeah. She should, I think, be waiting there to take part.
Like Bridget is in the room. Here we go, Bridget.
I see the Dark Lord has got himself an apprentice.
Morning. Okay, I can see Dr. Brash. I can't see Bridget. Oh, there you go. I can see Bridget. Good morning. So good morning to you both. Thank you for being with us. We do have you with us for up to 10 minutes this morning. So if you can begin your oral submission, we appreciate that.
Thank you very much. As you say, I'm Don Brash. I'm one of two spokespeople for the Hobson's Pledge Trust. Hobson's Pledge is an advocacy group with some 140,000 supporters. We're named after Governor Hobson, who of course said in the Maori language, as each chief signed the treaty, we are now one people, and that's what we fundamentally believe. Hobson's Pledge supports this bill. When Parliament passed the Marine and Coastal Area Act back in 2011, it was confidently asserted by both the Prime Minister and the then Minister, Chris Finlayson, that there would be successful claims by iwi for customary marine title around the coastline, but they would be rare because they would need to display continuous and exclusive use of that piece of coastline since 1840. The courts have clearly reinterpreted the meaning of exclusive. They've added a concept called shared exclusivity, which makes a total mockery of what Parliament intended. So we feel strongly supportive of this bill as it tends to amend the original Marine and Coastal Area Act. Having said that, if we had a choice, we'd go back to the Foreshore and Seabed Act in 2004, where the Crown owns the foreshore and seabed on behalf of all New Zealanders. But that isn't on the table. So we support this bill, and Bridget will add some comments about some specific details which we think would improve the bill.
Thanks, Don. So I'm Bridget Norton from Franks Ogilvy. We act for Hobson's Pledge, but we also act for the Landowners Coalition, who is an interested party in the Edwards matter, which comes up before the Supreme Court next week. They are submitting separately, so I'm not going to speak directly to their views on the bill, but being informed by our participation in MACA hearings over the last 5 years in particular, we produced a legal opinion for Hobson's Pledge, just drawing attention to some aspects of the bill that we think could frustrate the purpose of the bill. I want to leave as much time for questions as possible, but I wanted to particularly draw the committee's attention to this opinion. It is its supplementary one of the submission, and particularly to paragraphs 33 to 51. This is where we talk about the role of tikanga.
Oh, no.
In brief, there's a two-stage test that has been established for customary marine title. Tikanga is explicitly taken into account in the first limb, and the courts in the Edwards proceedings has read in the second limb. The minister has been very explicit that they wish to take the test back to what is originally Parliament's explicit wording. Unfortunately, we do not think the mechanism in which this bill does that, which is the new subsection 1, capital A, where it removes any consideration of spiritual or cultural considerations, will do so, and just draw the committee's attention, as I say, to the role of tikanga and how courts have treated tikanga as something beyond a spiritual or cultural norm within our law. But happy to take any questions.
Thank you, Bridget. Dr. Brash. So members, just so we can get the process right. About that, it's just double checking. If you have a question, please indicate by using the raise hand icon, and then I can pick that up from the side that's there. So first question is from Dr. Duncan Webb.
Kia ora, Mr. Chair, thank you for that, and interested to hear those submissions. I'm just a little interested in your views around customary rights. I think I've got probably two questions if I've got time. One is kind of more philosophical. Given that a customary right, if established, is simply recognising a property right which has existed from 1840 on, what is the kind of underpinning for suggesting that that property right should be expropriated without compensation with a return to the original Act?
Bridget, you going to answer that?
I think I'm not sure if you're referring to this particular amendment bill that seeks to take away any customary marine title that has been already, in some parts, been already awarded, or are you talking about if there was a return to the Foreshore and Seabed Act?
Well, the Foreshore and I'm really referring to the Foreshore and Seabed Act, but it's fair to say that even if this amendment was passed, there are people who have litigation in train who would have rights deprived from them, which have essentially crystallised, which would pretty much fit the definition of expropriation. And I'm just really perplexed, given Hobson's Pledge reputation for being an upholder of property rights, that you'd want to see them removed.
I don't think there's any suggestion that we want to reverse existing decisions of the court. My understanding is that those will stand. What we're saying is where the court has not made a decision, the courts should be guided by what Parliament intended. And right now they're not being guided by that intention.
Well, that's not exactly how the legislation works, and it's clearly been recognised as retrospective. But let me go to my next question, and I'm just curious about your stance on concurrent exclusive rights, because it's pretty well established, and in fact English law has long recognised the ability to have concurrent rights into a single piece of property, whether that be a right to hunt deer for one person and cut wood for another, which is, the old law of the forest, or simply land law, where you can have licenses in respect of the same land to do different activities on it, mine it and farm it. So I'm really perplexed as to why you say concurrent rights in respect of marine areas are foreign to the law when clearly it's well recognised.
So I will take that question. I think there's a difference between different use rights in terms of property rights and shared exclusivity. So in this context, we're looking at multiple iwi or hapu having the same rights, say collection of seafood or fishing rights or the ability to place rahui on a particular coastline. So they're not independent of each other. They can be the same right over the same area.
Can I just clarify then, if one iwi had a right to collect shellfish and the other had a right of passage with their waka, would you accept that we should have a piece of legislation which recognises those as customary rights which can coexist?
So they would still need to meet the test under the law, which they need to show uninterrupted, exclusive use throughout. So therefore, if the ability to launch
I want to interrupt
and the
this
ability to
submission.
collect Moana.
Go ahead.
Oh no, let it finish. Tukata Ferris is gonna cook her in a moment.
Oh, okay.
Were able to
We'll take a
operate
break
without
before
having
coffee.
interrupted each other's use, then that would indicate that is allowable under the MACA.
All right. Okay, thank you. We'll let someone else ask a question.
Okay, before Takutai Ferris literally sits down there and reads the Riot Act, does it just feel a bit bland and like they have to think about their answers? There's no talking points?
Yeah, let's get. You think Don Brash, he's like, oh, William Hobson said this thing. Say the thing he said. Go on. He iwi tahi tato. Now point to where that is established in the treaty. Okay? I mean, for all I care, William Hobson could have said skibbity toilet to every chief that walked on up. Does that have any legal binding? Is that what the rangatira agreed to? No, they agreed to what they signed.
Yep.
You're very quiet, Chris.
No, this is quite interesting because I have not kept up with the foreshore and seabed over the years, but this whole thing just reeks of expropriation of customary title that kind of goes back to the Māori land courts of the 1870s onwards, and it's like this is just a continuation of that very Eurocentric idea of there can only be one. It's like, why can there only be one when Te Ao Māori accepts that there can be many and shared, and it's not tied up in this notion of exclusivity?
I want to know why the libertarian, Mr. Don Brash, or Dr. Don Brash, as I should call him. I better call him Doctor, otherwise his lawyer's going to get on to me. I want to know why he thinks it's okay for the government to hold on to land that was seized via the New Zealand Settlements Act of 1863 and the Native Land Rating Act of 1882, which unfairly put higher rates on Māori land compared to Pākehā land. That's not libertarian, if he's supporting that. That's authoritarian.
Okay, let's continue.
Takutai has his hand up.
Yep, I'm calling for
I've got to say the use of the technology is still not
Chair,
good.
you're not being heard well
Okay.
through the.
Oh, I apologise. Hang on one sec. Sorry about this. Question from Takutai.
Tēnā koe te che. Tēnā koe Takutai Brash. Korua koto hoa.
Careful, he
I
might
have a
ignite
raft
some
of
fire.
questions, but I'll just ask you a couple here. With regard to your framing and approach to the marine and coastal areas bill, do you think that, or do you deem customary title, which Māori have been allowed to pursue within the parameters of the law, equates to ownership or some form of ownership?
Well, it's clearly a kind of ownership. It enables the group which
It's
has
concept
that
of
right
ownership.
to exclude others under certain circumstances. So it clearly is a
Ow.
form of ownership.
Or killed up, so it's a form of ownership. Māori have long utilised their own coasts in conjunction with neighbouring iwi and iwi that they may have had a relationship with who lived way in the mountains. At the arrival of early Europeans, Māori continued to share the use of their coasts with those new people. In 2004, all of the rights that Māori possessed relative to the coasts that they occupied were confiscated. And a test was established, the exclusivity test. Now, I would implore you to consider that Māori have the right to share their coasts with whoever they deem suitable, while still maintaining their mana over that same coast. So that's a Māori point of view that I would really like to hear what you have to say about it.
It's also a Pākehā point of view too, when you think about it.
Yep.
Do you have to share land?
I'm not quite sure what I would say about that, but clearly it's been long established that no, I'm not sure how to answer that question. I need to take it on notice, I'm afraid.
You probably never thought about it.
Have a view as to what I've presented?
I think if you look at the experience of the MAC hearings to date and the applicants' evidence that they have put forward, that there may be some circumstances in which that has occurred where there has been agreement, and that would not, I don't believe, necessarily mean that there's been substantial interruption where there's been agreement of use. But you see through the competing of applications that actually there's many iwi and hapu that have not agreed use and actually have declared separate applications and separate evidence as to their own exclusive use.
Do you, just quickly then, I don't want to take up all the time, just quickly, do you think that declaration of exclusive use has come about as a case of Pākehā law?
Pting.
So we are operating
in response to, sorry. So iwi and hapu who have put in exclusive claims excluding a neighbouring hapu or iwi, do you think that that's a symptom of having to deal through Pākehā law?
So as a lawyer, I operate under what the law set by the New Zealand Parliament. I don't define the difference between Pākehā and non-Pākehā law.
So
that is the end of our time. Apologies for the audio issues before. So thank you to Dr. Brash and Bridget.
I want to point something out really interesting. I've got this in my notes about English common law. So English common law, and unfortunately I can't really share the link to the research here, but it's from Auckland University. English common law was developed to accept that when English law is transposed onto a new country, the laws of the indigenous inhabitants survived the assumption of British sovereignty. I think that's a really interesting component of English common law that I think is being ignored here.
Yeah, there's a whole lot of stuff that's being ignored in this very, very simplistic approach to things, and I wonder, the whole idea of the fee simple idea of owning land, that survives whether you're in occupation or not, and it survives all sorts of things so long as you pay your dues. Then nobody's going to claim that you don't own it or don't have an exclusive right that is continuous just because you don't live there. It seems there's some very high bar that's being set here for a group who predates an agreement, being Takutai, to prove that they've had an ongoing interest in the area. And indeed that came up with one or two of the other submitters who basically put forward precisely that point. Just because we've been unable to get there or are no longer resident there does not mean that our interest in the area has been wiped away, extinguished.
Yeah, I mean, that's true. That's true. A Kiwi Skirt in the chat said that didn't make much sense. So basically, it means that when you apply English common law, right, it makes provisions for Indigenous law to stay intact. So tikanga. So that's a really interesting part of British common law right there. So basically, with the signing of the treaty, and I'm not a lawyer, so please don't quote me on this, but yeah, basically with the signing of the treaty, part of that under English common law also acknowledged the tikanga that Māori, that rangatira also followed when it came to land use.
Whenever I hear common law, the most common place I remember hearing about common law was on the TV show Judge Judy. Because many of the practices she used was English common law when it came to her rulings.
Yeah.
So when I keep hearing common law, I automatically think of Judge Judy. I don't actually think of, the whole process of what's been here. Now, there's another one that you've suggested, highlighted on here. On its part 2, was it Rangatana was it
Tumaira?
Yeah.
Tumaira. Yep. So Tipeni Crisp. And I found his submission to be very important because Rangatane has a lot of overlaps with other iwi in my region. So you got Ngāti Kahungunu ki Wairoa, Ngāti Kahungunu ki Heretaunga, Ngāti Kahungunu ki Wairerepa. There's a lot of overlaps there with those iwi, and I'm a member of Ngāti Kahungunu. So yeah, that's part of the reason why I wanted to bring up Tipeni. And also, I like Tipeni. I've met him before. He's a cool guy. So I would love him to see him debate David Seymour.
Tēnā koutou.
Kia ora, Tipeni. Thank you for joining us. We have you for 10 minutes this afternoon, so we'll hand over to you.
Thank you. Tēnā koutou, and thank you for the opportunity to present an oral submission this afternoon. I'm going to expand on some of the key points in the Rangitane Tumaira written submission, which I'm happy to take as read. I'll begin, just for the avoidance of doubt, to be very clear. Kārea Rangitane te tautoko I tēnei pere. Rangitane does not support this bill. Our strong recommendation is that it is referred back to the responsible minister for further development. There are a couple of matters that are of particular concern to us, and I acknowledge the previous submissions and endorse the comments from Ngāti Rehia, Ngāti Tamoho and Ngā Rangahautira. Rangitane is particularly concerned about the proposed amendment to Section 57 of the Act of 2011 that would require applicants to demonstrate both the intention and the ability to control the area to the exclusion of others from the start to the end of the applicable period without substantial interruption. We're concerned about that at a number of levels, but I think I want to highlight this afternoon. We are unclear about what is meant by the phrase, the ability to control the area to the exclusion of others. We are concerned that this lack of clarity will create substantial uncertainty. Having watched back the first reading of the bill, the Minister and other speakers did not address this particular point. Rangitane has a significant history of using all the legal means available to us to uphold our rights and manage our interests. This has often happened in opposition to the government. It has often happened to no avail. That history is set out in detail in the Wairarapa ki Tararua Waitangi Tribunal report, and there's a particular description there of the events around Wairarapa Moana that speak to these matters. Us using all legal means to uphold our rights and manage our interests in opposition to the government to no avail. My question is, if we have used all legal means available to us at any given time over the last 180 years to control our Takutai Moana, does this constitute the ability to control the area? The second matter I would like to speak to is our concern around the various constitutional implications arising from the bill. And just touching on the presentation from Ngā Rangahautere, we share the concern that the approach set out in this bill seems to override many of the checks and balances that are built into our constitutional arrangements, including Te Tiriti o Waitangi. The government is not above the law. It cannot change the law to suit its whims of the day. In our treaty settlement, the Crown solemnly promised Rangitane that it wished to restore its honour, atone for its wrongs, develop a new relationship with Rangitane that has mutual trust and respect for the treaty and its principles as its foundations. Changing the rules of a legislative process halfway through proceedings because you do not like the results so far does not fulfil the terms of this promise.
True.
Koe rā ku tāpaitanga kōrero I tēnei ahiahi. Tēnā koutou.
Kia ora, Tiffany. Thank you for providing us with your submission. We'll go to a question from Huhana Linden.
Tēnā koe te matua, Tiffany, e mihi nui ana kia koe waha mai nei ngā whakaaro o Rangitane. I'm just wondering about, we've had iwi come online and share the ongoing struggle that they have had in te whakahaere I ngā rawa, ki roto I te papa Moana, but also defending the health of the Moana and our waterways. This is a good education process, matua, for our panel members, because rawa rātou tino mārama ki te hōhunutanga o te whawhai o te iwi Māori. Are you able to share a bit in terms of Wairarapa Moana and how you have continued to stress and oppose and raise concerns mai rāno for the health of our Wairarapa Moana? Is that not enough of a demonstration of that ongoing connection from 1840? Tērā tohe?
You'd think so.
Tēnā koe Huhana, this is a good example described in detail in the Wairarapa ki Tararua report, whereby locally we continue to own the land around Wairarapa Moana. The River Board, with the tacit support of the government, opened the channel of Wairarapa Moana, impacting the ability of iwi to manage their resource. They did that knowing full well that it was illegal. Iwi protested, iwi petitioned government. There was a royal commission. Iwi went and sort of undertook peaceful demonstrations to say, dear local council, local government, central government, please stop doing this. That was all in vain. So, every legal mechanism that was available to us, we used, but the government continued to take steps to open Wairarapa Moana to the Pacific Ocean, in effect undermining our ability to manage our asset in a way where, and sort of having exhausted all legal means, and this went on from the 1850s through to the 1890s, we were forced into a compromise situation. And that's just one example, sort of along the Wairarapa coastline. We've petitioned, we have put in place rāhui, we have worked with local landowners, we've used all the lawful means available to us, and sort of pushed the boundary as much as we can. And surely Parliament is not intending that we need to use extra legal means to maintain our rights and interests, this ability to manage the area to the exclusion of others. Surely it must rely on us using the legal means. And as I say, Huhana, if we've used all the legal means and other parties continue to invade our space, what are we supposed to do?
Thanks, Matua Tipene. Members, I've put into our chat Y863 Wairarapa ki Tararua report, because once again it provides a window of a case study of the way that local Māori have fought for the health and well-being of their waterways, which to me demonstrates the customary connection that our people have had mai rāno over the generation. So thank you very much, Matua. These are important kōrero to be shared with our panel members as we discuss this very important issue for te iwi Māori. Ngā mihi.
Cool. Thank you, Huhana. Thank you, Tiffany, for your time this afternoon and for providing some context to your submission. We do appreciate it.
Yeah, so the reason why I wanted to look over that submission is because, like I said, there's a lot of shared exclusivity because Rangatane shares a lot of territory with other iwi and hapu within Rangatane. You know, it's not uncommon to have Ngāti Kahanunu and Rangatane living in the same neighbourhood. So I don't know what the government wants to do. Do they want to have a Swiss cheese approach? Do they want to make the map look like Swiss cheese? It's just easier just to have shared exclusivity. And yeah, it's like this hits home to me because I grew up not being a part of the Māori community. I grew up being around people who held opinions pushed by Hobson's Pledge, saying the Maori are going to take your water, and that really impacted my view growing up of Wairarapa Māori. Well, it's been like 20 plus years now. The Māori haven't taken the water because there's nothing in the legislation that says Māori own the water. It's not there. It's just a myth.
I mean, what do they expect? Suddenly, there's a dam that's suddenly going to sit down there and, you know, with a Māori sitting at the top, going to be turning on and off a tap when they sit there and feel like it? I mean, I've not seen that in New Zealand. Even you know, I do remember it being fear-mongered a lot as a kid.
Yeah, do they think Te Penny's going to jump out from behind a sand dune and chase them down the beach with a patu, telling them to get off their land? I mean, come on, it's like, let's be real here.
Yeah, but what it also shows is this astonishing ignorance on the part of Pākehā New Zealanders about how Māori actually want to live their lives with those who have benefited from Te Awatangi. You know, it's just, I don't get it. I've been in tertiary education for a very long time, and every time I have conversations with Māori educators involved in supporting their rangatahi and all the rest of it, it's like there's no exclusion, there's no it's ours, there's how do we help our people, and by doing so help everyone else. It's like the presumptiveness of the approach by these people who want to go and alienate the natives, and it just continues on, and it's like what is the fear that is driving this? What is the fear that they are giving voice to?
I don't know. Like from
it's not based in reality.
It's not, and you know, from a te ao Māori perspective, you don't own an atua, you don't own Papatūānuku, you don't own Tangaroa. What you do own is the rights to utilise the assets that are presented there. That's what this is about. It's not about actually owning the physical thing itself.
So does that mean we can sit there and put, say, a hydro water turbine down there that produces electricity and sell it to the grid?
If you do it with the consent of the iwi, if you work in collaboration, this is why I'm a big fan of co-governance. If you work in collaboration, sure.
Yeah. I think also if you put this particular piece of legislation with its very high bar in context of the fast track bill as well, it's all part and parcel of the same approach, the same mindset. Drill it, mine it, road it, baby.
Should we see?
I wish they fast track all these claims. That'd be nice.
Oh,
yeah. How long have you been going on for?
Since 2017.
Did you put in a submission onto the District Court Judge Amendment Bill? Was it Amendment Bill or whatever it was called? Because I put one there saying I support the bill, but I don't believe the judges are enough. We need, say, at least 200 from, what was it, 187?
Yeah, we need more judges for sure. Oh, absolutely. Yeah, one is just, what the hell is one? Come on, you're the party Law and Order. Put 1,000 on.
Yes.
Put 1,000 on. Yeah. Should we kick over to the next submission? I don't know who it is, but it looks interesting.
This is going to be fun.
Oh, yes.
Remember, so the next submission will be from Te Kahui Maru Trust, and joining us will be Sam Tamarapa and Casey Bellamy.
I like the sound of this.
Hmm.
Good team to think alike.
Kia ora, Sam. Thank you for being with us. You can hear us okay?
Yes, I can. Tēnā koe, te manga, e ana kia koe, e tautako nā miki ko mi. First of all, I'd just like to sort of start off and just make sure that in terms of the written submission that we provided, that you have copies of it and the panel has read through them. But the points that I want to talk to, and it just really summarises the submission that we have, is that Ngāti Māori, the Kiwi-Bird Trust is basically the post-settlement governance entity for Ngāti Māori Wharenui ki Taranaki. And basically what we're saying here in our submission is that we strongly oppose the Marine and Coastal Area Takutai Amendment Bill on the grounds that it undermines the rights and interests and responsibilities of mana whenua from the coastal and marine spot areas. The bill constitutes a breach of the Te Tiriti o Waitangi and seeks to undermine the rights and interests in the Takutai Moana along with the role as kaitiaki in these areas. But just to sort of flesh that out, the speaking points and the summary that we have. The Takutai Moana is a significant taonga for all Māori, and including Ngāti Māori, and because it's been held in such high regard, and yet we as Māori and we as Ngāti Māori have not been given the opportunity to engage as treaty partners and exercise our tino rangatira on the significant issue. We concur with the findings and the recommendations made by the Waitangi Tribunal in the pre-publication report on Stage 1 urgent inquiry of the Takutai Moana Act amendments. We support the written and the oral submissions made by our Manaunga Iwi and Taranaki and Ngā Iwi o Taranaki. Further to that, in terms of the policy development, in our view, it has fallen well short of best practice. The Crown seeks significant amendments to that without any evidence of support where there is a problem. We expect to engage with the Crown in a robust policy development process using evidence and engagement to inform problem definition through to implementation. Like many changes being proposed by the government, the problem definition is lacking and non-existent. The changes are politically motivated, seeking to deliver on election promises at the expense of Māori rights and interests. But this undermines the Māori-Crown relationships. And for Ngāti Māori, that is a really key point in terms of the current relationship we have with the Crown. So with the number of I suppose changes that are being promoted by the current government, and we have been submitting time after time in terms of a response to what the current government is doing. So yeah, so the real big problem is the relationship that is there. I mean, if the current government continues down this line, then that's at serious risk. The other point too is what we like to make is the environmental and cultural impacts. The changes will make it more difficult for Māori to obtain customary Māori title, which will have adverse effects on Māori values and the ability to exercise kaitiakitanga and risk exploitation of taonga, harming both the environment and cultural identity. And of course, the last bit, the treaty partnership. The lack of proper consultation is contrary to the principles of Te Tiriti, where Māori partnership, protection and participation are essential. So, in short, this is the submission on behalf of the Kiwi-Bird. So, quite happy to take any questions that the panel may have.
Kia ora, Sam. Thank you for your submission and for providing some additional context to that written submission. Members, I'll hand over to you for questions if anyone has something they'd like to raise with Sam. Takutai first.
Tēnā koe, te rangatira e hāmi.
Tēnā koe.
Me ngā kōrero oti nei a koe te whakatakoto mai ki mua ki Tarawaro o tēnei komiti. Sorry that our panel isn't fully engaged in responding to a lot of the things that have been put forward by yourself. It's been the case all day. You and I know, and we know the challenges that this represents, and the continual. It's been described today as shifting of goalposts, deceitful activity, unilaterally rewriting the law, and so on and so forth. What are the, in the face of significant adversity, which is where we find ourselves, unfortunately, in 2024, an adversity that no one with a living memory has had to endure at the hands of a government. So given that we are in a time where our options are being radically and significantly reduced at an astounding speed, what do you see are the real on the ground options? They're on the ground options for your people when it comes to you wanting to maintain your presence in kaitiakitanga. You wanting to maintain your presence in hononga ki te whenua. Maintain the future aspiration and hope for your mokopuna to have all of those things. What are the options left to you, Matu?
Well, yeah, they're disappearing quite quickly in terms of the options that are open to us. I mean, we've gone down the legal track on many occasions, and just listening to the previous kōrero around what those examples would have been. I mean, we've got a 30-kilometre rahui in place by one of our iwi here in Taranaki, and it's purely to look after our kaimoana beds that were severely impacted. And this was done in a legal manner. So we used LAW to initiate that. But obviously, in terms of LORE that we have, I mean, it's our people that are on the ground that are out there making sure that that aruhi is being adhered to. And right across in our community here in Taranaki, there is wide support from across the community for these things. So in terms of the ability for iwi Māori to actually put processes in places that actually work for us, and using the tikanga that we have, but also not being frightened by looking at the LAW and using those sorts of things. So, that's for us, that's a real example in terms of how we do things here in Taranaki. But, to go to the heart of the matter of what you're talking about, the adverse effects and what options do we have, like I say, they're not a lot. What we are asking for is to actually pull back on this, us in the Crown, to actually pull back on introducing this, and to sit down and have some robust discussions with Māori, with Ngāti Maru, to actually step our way through this process in a proper manner. And then I also made that point about in terms of the relationship, because our relationship is not getting better with the Crown. It's going the other way. So in terms of the longevity of that relation, it hasn't. And of course, you would know, we're an intergenerational people. And of course, we're struggling with now to maintain that relationships. We're not getting here right at this moment in responding to the issues that the government's putting in front of us.
Kia ora.
So those options are very quickly disappearing on us. And again, going back, the opportunity to actually sit and go face to face with the government, to actually have a proper discussion. And let's reflect the treaty. Let's reflect that partnership in terms of being able to participate in the discussion. So, I don't think I can add much more than that.
Ka pai. I'll let Huhana have a kōrero, but engari tēnā koe.
Oh, well, thank you, Sam. We'll take a question from Huhana London.
Tēnā koe matua, Sam. E mihi ana kia koe. Good to see you.
Pai ki tāno.
I just wanted to ask and inquire, we have Taranaki coming in strong here across the coastline, raising concerns around that mana whakahaere impact in terms of ngā rawa o Tangaroa, but also our Papa Moana. And I do want to ask about your thoughts in terms of, we've got fast track coming in.
Yep.
Our deep sea, our deep sea mining, all of that exploration. That's why CMT is so important for our people. These are one of the tools for our people.
Yeah, I tika. Yeah, so in terms of the fast track I mean, we obviously we're not a supporter of the fast track. And in terms of our whanaunga, in terms of mai te tonga o Taranaki, Ngāti Ruanui. Yeah, so collectively, we actually work collectively together on many occasions, and in this case, this is one of them in terms of the sand mining. So, and on other events too, but the sand mining one, yeah, a really difficult one, and for Ngāti Ruanui, it's definitely going to be an uphill battle. But we were the iwi and Taranaki will stand behind them. We will support them. But that just emphasises in terms of the taonga that we're talking about in terms of Takutai Moana. It's not just about the water. It's not just about our kai moana, which feeds all of us. It's about those other values that we have in there, like sand mining, what's been targeted in the sand mining. And of course, on top of that, we had the potential in terms of alternative wind energy, which would have been in the same space if it was allowed to proceed. So you can see in terms of the strong support Ngāti Maru has for Ngāti Ruanui and for all our iwi in the south of Taranaki in terms of helping them to sort of address the issue around sand mining, but also looking at the alternative energy, which we think will actually bring more positive benefits for Taranaki as a whole and for the country as a whole.
Thank you, Sam. Thank you. That's the time we have, so I appreciate you being with us this afternoon and speaking to your submission.
Kia ora, tēnā koe.
Members, we have a break scheduled in, but
I will admit I didn't do too much. I wish I had done more research into Taranaki, but his submission ties in really nicely with the Crown Minerals Amendment Bill and what's happening on the coast. It reminds me quite a lot of his concerns. Like, this man looks like he's gone through a lot of shit. Matua over here. But yeah, he looks like he's gone through a lot of legal stuff.
Well, and also mentioned a bit about how the proposed wind turbine has been effectively shelved thanks to the Crown's Minerals Amendment Bill.
I think we all did a collective sigh when we heard that one.
Yeah.
But it just reminds me of like the Tui oil field and what happened there, and it's just like, oh damn, it's so frustrating.
Oh, I remember the education you had to give to Dr. Eric.
Yeah. Any commentary, Chris?
Yeah. The one thing that strikes me about this government is that they're moving fast and breaking stuff. Or are they breaking stuff and moving fast? I don't know. It's one way or the other.
They're doing both.
Yeah, they're certainly doing both. And Sam mentioned there the quality of the relationship is kind of key to all of this.
Mm-hmm.
And it's quite evident from the fast track, the Crown Minerals, this particular bill, that the Crown, this government, is not interested in the relationship. They're interested in, as he himself pointed out, motivated to meet coalition agreement points. And I guess it's a lesson in government or governance is that if you want to do stuff, get on with it. And that's exactly what this government's doing. And they're not stuffing around, and they're not waiting for anyone else's opinion. And they're certainly not interested in the evidence.
No.
Because they have an ideology to work forward, and the ideology is what they agree with. And when I flicked through some of the other submissions for this particular bill, it kept coming up. What you're doing is running contra to the expert advice you received in the papers that supported the original bill. And you're not paying attention to the evidence that was supplied, and it's just like, why is this becoming so familiar as a retort to what this government is doing? This government does stuff, and people turn around immediately and say, "Where's your evidence?" And good old Nicola Willis was caught out with, "Where's your evidence for returning to work?" It's just where's the evidence? Well, we don't need evidence because we have an ideology, and the ideology says. And we're running with fearful people who don't want to talk to their neighbours or others who have an interest in these things either. And it's just, and like you say, Sam, you can see written all over Sam. He has been in this mill a long time, and
he's fought some legal wars.
Yeah, and it shows, and he's kind of over it. That's it. He's here we go again. It's just man. But the other point he said is the relationship's not getting better. And you can put that alongside the fact that te ao Māori, or te ao, not Māori, but te ao, our environment, that isn't getting better either. And the more the relationship between the treaty partners as kind of the peak relationship within this particular country deteriorates or is neglected, willfully hacked away at by one of the partners again, so the whole situation deteriorates. And you can see there's a connection there.
Absolutely.
Better.
Yeah, and there are common themes throughout all the submissions presented by Māori, and it's just that the government doesn't give a shit. It's just like they're okay with just taking land, holding onto it, selling the rights off to corporations. They don't care about Māori.
It's
and they don't care about the damage either. They care about the profits and the mates.
That's what happens when you get a guy who wants to run the government like a business. This is the outcome.
Yeah.
We probably are seeing the first true politician trying to actually run the country like a business. I mean, this is something that commonly happens in every council election. Council can't be run the way it's doing. It's broken. It needs to be run like a business. And even one or two of the first things that come in when they run it. What? We only can collect rights?
Yes.
Or the other one is, it's going like, so how do I lower my rates bill?
Or get my road sealed. That's the other one.
Oh, yes. That's probably the latest one. Yeah, get my road sealed. Yeah. Or turn my local roadway into a 6-lane, 120-kilometre highway outside a hospital.
Sounds fair.
That was someone did a sarcastic post on there to take the piss out of bike lanes in Newtown, and it basically, if you read it properly, you would be going like, "Oh my god, they're taking the piss," but a whole heap of people would go, "Look, the council's closing down this business." But if you sit there and followed it, it's it basically takes the piss out of based on the stereotype is. Only people in cars eat. Only people in cars have money. People who walk, people who cycle, people who come in any other mode other than a car don't spend money.
Yes.
Yes, Kiwi, just also to let you know, my volume's set at 70%, not 100.
Sam's yelling is good for you. Enjoy it.
And particularly I do feel a bit flat today, but that's because I have not had a good day in sleep. So I missed my alarm clock this morning for the paper, and so instead of me staying at 2:15 this morning, it was 3:15, which means when I got home, it was 6:45.
Well, don't worry, you're going to enjoy shouting at this next submission if it's the one that I'm thinking of.
Let's go.
But we are running well over time, so we're going to push through and move to our next submitter. Next submitter is Dr. Muriel Newman, joining us from the New Zealand Centre for Political Research.
What was that, ideology? Yes.
I don't know. Cooked? Ideology?
Yes. I prefer ideology.
Ideology?
The great news is you can still hear everything, even if you're away from the camera shutting the
Thank you, Dr. Newman, for joining us. We can hear you. We can't see you right now. Here we go. We've got you both on screen. So thank you both for joining us to speak to your submission. We have you for 10 minutes this afternoon, so I'll hand over to you.
Don't jump out of the window yet, Sam.
And thank you to the committee for giving us the opportunity to present on our submission to the bill. I'd like to start with a few introductory comments, if that's okay. My name is Muriel Newman, and I was a Member of Parliament for 9 years. On leaving Parliament in 2005, I established the New Zealand Centre for Political Research, which is a public policy think tank. Given the importance of the coast to all New Zealanders, that's social importance, economic and national security importance, we've been following developments in the foreshore and seabed area for a very long time. right back, from the time that the foreshore and seabed was held by the Crown on behalf of all New Zealanders, to the 2003 controversial Court of Appeal ruling,
I need a red buzzer.
which essentially said that discrete pockets of customary marine title might still exist, to Labour's 2004 Foreshore and Seabed Act, and then the 2011 Marine and Coastal Area Act. And that, of course, allowed tribal claims if the claimants held the areas exclusively and continuously since 1840. But importantly, it guaranteed that public access to the coast would not be restricted. When the 600 or almost 600 overlapping claims flooded in on the eve of the 2017 deadline for the bill, for the law, we felt that we should get involved in the process to try and ensure that the law delivered on the promise that it had made to New Zealanders. So we raised the funding and we supported 2 community groups to lodge notices of appearance on all of the claims. We wanted to give a voice to recreation users, so we supported the Council of Outdoor Recreation Association of New Zealand, and a voice to property owners, so we supported the Landowners Coalition. And
Just
as
not
a
the money
result,
ones.
over the years, we've been involved intimately in 2 High Court cases, 1 Court of Appeal case, and the Supreme Court case is scheduled for next month. And it's very clear to us that the law is not delivering on what Parliament intended. So we strongly support the law change, and we'd like to take this opportunity just to make 6 suggestions to improve the law. And I'll just run through very quickly what they are here now. First of all, we believe there should be a public submission process in the whole High Court claims process to ensure that judges are better informed. Such a process is built into the direct negotiation process with the Minister. And, the High Court process is adversarial, and it was thought that a lot of community groups would involve themselves in it, but the costs have ruled most of them out. As we know, claimants got up to $458,000 to prepare and present their claims, but anybody opposing the claims got nothing. So we think that the Attorney General should set up a little process to allow public submissions on each of the claims so the judge is better informed to make his rulings. Secondly, we believe that tikanga should be removed from the law. The problems with the Act that arose are mostly because the judges looked at the tests in the law through the lens of tikanga. And now the tests have all been tightened. It really means that tikanga is less relevant. And I think to make sure that the law doesn't go off the rails, it should actually be removed entirely. We also believe that wāhi tapu should be removed from the law. Wāhi tapu hasn't become an issue yet because that's the second stage of the claims process. First, customary marine titles are awarded, and then those title holders are asked to present their wāhi tapu claims to the court. At that stage, it probably will be extremely controversial. But by preventing public access, wāhi tapu they're inconsistent with the guarantee that public access would not be restricted. And that was a promise that was made by Parliament.
She doesn't know what a wāhi tapu is.
Next, we remove that shared exclusivity and joint title should also be removed from the law. The Attorney General, when responding to those hundreds of claims that flooded in, initially stated that overlapping applications were inconsistent with claims of exclusive use. And we believe that what's happened is that the idea of shared exclusivity and joint title has been introduced by judges into the law to circumvent the actual fundamental right or issue that was presented in the law, which was that you can only gain a title if you have exclusively used it without anyone else being involved. So we believe that it should specifically state in the law that shared exclusivity and joint applications should be removed. And to avoid any doubt, we believe that any new application lodged after the 3rd of April 2017 strict deadline should be ruled out. Next, we remove the provisions relating to resource consents and mining royalties should also be removed from the law. Nobody envisaged that there was going to be so many claims. A previous minister reckoned it was going to take 20 or 30 years to resolve.
How many shares do you think she owns in the mining companies?
So asking resource consent applicants to consult all
How much money
claimants
does she take from them?
is just totally unreasonable. Sometimes there's 20 or 30 claimants in an area. And similarly, withholding mining royalties from the Crown for that length of time, again, is totally unreasonable. And just finally, given the magnitude of the problems of interpreting the law, in spite of the clarification that's in the bill, we strongly recommend the inclusion of a review period so that after a short period of time, the Crown can have a look and see whether the law is delivering what it intended. So that's essentially what we presented.
Probably the
and
only
I'm happy to
sensible
take
thing
questions.
she said.
Thank you, Dr. Newman. We've got the first question from Takutai first.
Tēnā koe, Dr. Newman.
Sorry.
I know there's a lot of things you think should be taken out, and that's Kate Pai. Everyone is welcome to their opinion. How do you think that the law, the proposed one, should give effect to Te Tiriti o Waitangi? Very, very simple statement. Very simple question. If you think that things like tikanga should be taken out, wāhi tapu should be taken out, shared exclusivity should be taken out, these are all things that the Māori partner to Te Tiriti o Waitangi live by. So my question for you is, how do you think that Te Tiriti o Waitangi should be embodied or given effect to in the proposed law? The
Marine and Coastal Area Act contains reference to the Treaty of Waitangi. We're not suggesting that that is touched, so that can stay where it is. But what we are saying is that the reference to tikanga, because it is new to New Zealand law, it actually meant that the judges were not able to ascertain that there was a second test in the law. There was tikanga and there was the test of exclusivity. They totally ignored the test of exclusivity, and that's the High Court and the Court of Appeal, in terms of the way that it was written, in terms of what Parliament wanted. And so it's ended up by causing the trouble that we're trying to fix now. And in terms of wāhi tapu, as I said, we haven't gotten onto wāhi tapu yet in the Marine and Coastal Area Act. That's coming. And so I think in practical terms, both of those things could be removed. It won't affect the actual way the law is structured, but it will make it a lot easier for the law to go ahead and for people to either, get their claims or not, depending on how strong their case is.
And so you think that that's a reasonable embodiment of Te Tiriti o Waitangi?
What's that? Sorry, I didn't catch.
Oh, sorry, yeah. And so you think that that's a reasonable embodiment of Te Tiriti o Waitangi?
I'm saying that the provisions for the Treaty of Waitangi in the Act, we're not talking about those at all. They would stay as they are.
Okay, thank you. We've got 30 seconds left. Dr. Newman, with your indulgence, I think that may be Frank beside you, who will be preparing to be the next submitter. With your indulgences, I'll take a question from Duncan Webb and run a little bit overtime in this session. Is that okay?
Yep.
Thank you.
Dr. Webb.
Thanks, Mr. Chair. Just curious on your views of shared exclusivity and whether you accept that people can jointly occupy a space exclusively. Are you happy with it? I mean, is that something that you're comfortable with?
Well, no, this is the problem. The original law suggested that if somebody had held an area of the coast as if it was their own, which was the basis for them being able to claim a customary marine title, they had to have used it without anyone else encroaching on it. And this is where the judge in the High Court case, in the Edwards case, we believe made a fundamental error by saying because all the claims overlap, then we'll just grant a customary marine title to them all to be shared. And the Court of Appeal went down that track as well. And that's wrong.
The case that you yourself occupy your house with the guy who's sitting next to you exclusively and jointly.
Yes, got him.
Yeah, but that's different, isn't it? That's a joint property right.
Well, and there we have it, because we are talking about property rights.
No.
There's-
The original law was said that the claimants must have held it exclusively and continuously without substantial interruptions since
right.
1840. Now, to most people, exclusively means one tribal group owned it and not a whole bunch of them. If
Well,
they'd wanted a whole bunch
no,
of them
I
to have
think
owned
that's-
it,
I
they'd have
think
put it
that's-
in the law.
That's your overlay. Joint ownership is recognised in every legal system that I'm familiar with. Thanks for that.
I actually did jointly own it from the outset. I didn't come in lately and claim half.
Okay, thank you all. What we'll do now.
Walked into the spider's web with that one. Holy
Far
shit,
out.
that was a good setup.
This doesn't surprise me from a former ACT MP, and I've been doing a bit of reading. I didn't know before she ended up as an MP, she worked at Michael Hill.
Yes.
I would not have known that.
It's so funny because they're getting so tied up on what shared exclusivity means. Like, they forget the fact that hapu belong to an iwi, and iwi descend from a waka. One waka, one iwi, lots of hapus. You know, it's like, oh, okay, it makes sense to share, doesn't it? We share one title.
Oh, I wonder if she's one of these people who believes that was it on a bus there is seat exclusivity.
Yeah.
The only exclusive seat on a bus is known as the driver's seat.
Yep. Can we talk about wahitapu as well? It's like, come on. Look, lots of wahitapu are available for the public to go and visit and see, okay? There are limitations of what you can do there. Like, for example, I live down the road from a wahitapu. It's called Pukaha. No, you can't start a forest fire. You can't go camping there. I'm sorry. You can't disturb the kōkako that are flying around in the bush. But you can still go there and you can still enjoy the bush. No one's stopping you from doing that.
Sounds like you're sharing an exclusive activity.
Yeah.
Oh, man.
Oh, this whole thing about exclusiveness. God. But yeah, it makes it out like, it got exclusive rights to...
That was an object lesson of intolerance, that was.
It's just stupid.
Intolerance of a different worldview, a different way of being. And it ties in with what we saw with Don Brash, which is, we are one, but actually everything gets atomized to the individual and to the singularity. And it's just like, no, that's not the way people work.
Yeah, and also too, oh shit, I forgot my thought. There's just so much there to cover. I'm sure will come back to me.
One of the things that occurred to me while she was going through it was that, courts don't deal in fantasy. They don't invent stuff. They look at the evidence in front of them and they reach conclusions and determine which way they go. So
yes, I remember the points.
For them to have arrived at share exclusivity, it must have come from somewhere.
Yeah.
So they didn't just invent it.
No.
This is not a court fiction.
And also the false premise too that they're operating from. This is the point that I just remembered. They think that the majority of rangatira signed the English version of the Treaty of Waitangi. They did not. They signed Te Tiriti, which have different things within that.
But they also signed the preamble to the treaty.
Yes.
And the preamble to the treaty is the context of those 3 articles.
Yes.
And if you just forget the preamble as it's only preamble, then the treaty loses its full meaning. And you read the preamble, then you read the 3 articles, and you go, I see what was going on here. It was purely a recognition that actually our lot of scoundrels, and we need to have our laws for them. You guys, we want to protect you from them. So let's do it.
Sound like a broken record here, but I wonder how Muriel would fare on Judge Judy.
Probably not well.
Yes, but the other thing was that Ferris got stuck into him, and it's not Ferris, is it? That's his last name. Yeah, no, but he talked about is what you're talking about sufficient for Te Tiriti o Waitangi to be given effect to, and she talked about reference but not given effect to. So, you know, she said we're not talking about, you know, the reference parts to the treaty, but that's not giving effect to the treaty by the way the legislation is constructed, and also by the way that the consultation for it's taken place. You know, the question is what consultation, and it goes back to that relationship question. You know, this is
by the time they put the ad in the paper, the consultations have already closed.
Yes, done. I know. Yes, it's yeah.
I mean, the Waitangi Tribunal said it themselves. It's like that's one of the breaches that the Crown did. They didn't consult Māori.
Didn't consult.
Yeah.
Yep.
Okay, let's move on to Laura's next piece of recommendation, the New Zealand Law Society.
Oh, wait, before you go on to them, can you do her husband's submission?
Oh, is he?
Yeah, follow straight after hers, yeah.
Frank.
Yeah. I think this one made me more mad. And can she stop staring at me? My God.
You yourself occupy your house with the guy who's sitting next to you exclusively and jointly.
Yeah, but that's different, isn't it? That's a joint property right.
Well, and there we have it, because we are talking about property rights.
No. The original law was said that the claimants must have held it exclusively and continuously without substantial interruption since 1840. Now, to most people, exclusively means one tribal group owned it and not a whole bunch of them. If they'd have wanted a whole bunch of them to have owned it, they'd have put it in the law.
That's your overlay. Joint ownership is recognised in every legal system that I'm familiar with. Thanks for that.
We actually did jointly own it from the outset. I didn't come in lately and claim half.
Okay, thank you all. What we'll do now is we do need to move to the next submission from the Landowners Coalition Incorporated, which I do understand is Frank Newman, who is on screen now. So the clerk will, there we go, change the name over, and we will switch seamlessly into the submission from the Landowners Coalition Incorporated. So, Mr. Newman, we have, with your indulgence, eaten into your time a little bit, but we do have 8 minutes remaining for you.
No problem. Thank you very much. Thank you for the opportunity to have a say. The Landowners Coalition, I'm an office holder. We're an interested party in all High Court, all of the cases before the High Court, and we've been actively involved in the Edwards case in the High Court, in the Court of Appeal, and we will be involved in the Supreme Court case that is coming up next month. Our role is to act in the public interest and give the public a voice that they would otherwise not have. Firstly, I must say that it's a bit concerning that the concerns we expressed 12 years ago have come to pass, and here we are today, 12 years later, with correcting legislation.
Really?
I'm also saddened to say that we, the Landowners Coalition, will have to go through the whole legal process again.
Oh,
from the very
boo-hoo.
start.
Boo-hoo. And I'll just interrupt him here.
As it's been changed here today.
Boo-hoo. Let's forget about all the people who put in their submissions to get a customary marine title, right? And the fact that this new act is going to essentially get them to fucking resubmit everything. So, it's just like, oh, boo-hoo, think about our clients. Yeah, I'm sorry. Think about the Māori that have already put their claims in.
Yep.
Get in line. And vote for more judges.
Yes. Unfortunately, that submission has closed.
In my view, having been involved in the cases, the judges in the High Court and the Court of Appeal have actually bent over backwards to give the applicants customary title. And I find it concerning that the very same judges that made those decisions that are being corrected here today are still actively involved in managing the cases in progress and the 200 or so cases yet to be heard.
It's very known to be standard practice that the same judge tends to manage the case from start to finish. It is not known for you to sit there and go, good evening, today on the trial we have Judge Snyder. Sorry, spin the wheel. Tomorrow we're going to have Judge Judy Shyman. On Wednesday we'll spin the wheel. We'll have her husband Jerry. And on Thursday we will sit down there and have Chief Justice. Is it Helen Winkleman? Is that our current Chief Justice?
I don't know, but to them they're probably all woke or something.
Yeah, exactly. It's like we're like do they not understand the point of the court is to have the same person in there? If you have a court of appeal that smacks down a decision from a district court judge or a high court judge, it tends to go back to that judge to correct. Well, the opportunity goes back to that judge to correct first. And it's even under New Zealand law, not just US law, which we probably hear a lot more about these days.
In my view, that should send a very strong warning to this committee. And the warning is that the law that you make here today needs to be clear and unambiguous. There are 5 issues really I wish to pick up on today, and they relate to sections 57, 58, 59, 160, and finally I wish to make a comment about shared exclusivity. I'll run through these pretty quickly, but with section 57, it's the definitions. We agree with the changes, but what we'd like to see is some firming up of the definition of substantial interruption. And we would recommend this be done by way of an explanatory note, which obviously has no legal effect, but would be a guideline, if you like, to the people who are required to enforce this law and abide by it. So just an explanatory note with examples of what Parliament means by substantial interruption. On to section 58. Now that is the controversial one, and the committee will know it's section 58.1 is really in 2 parts. The first part is the tikanga qualification, and the second part is the continuous occupation and exclusive occupation since 1840. We believe the problem has been that the tikanga aspect has been conflated into the second leg, and that essentially is the problem that this committee is attempting to correct. We believe there's a better way to correct it because we believe there is still a risk that the tikanga qualification will spill over onto 1B, and we believe that should be cut off immediately to not allow the judicial discretion. We believe that can be done by removing clause 58.1. In other words, take the tikanga qualification out and simply rely on 51B.
And ignore English common law.
58.1B as the criterion. Should the committee wish to retain the tikanga clause, we believe a new clause should be added, 58.1C, which would specifically state that tikanga does not apply to 58.1B to make it explicitly clear and remove the judicial discretion. On to section 59, and that relates to matters of relevance to section 58. We believe it should revert back to the clause in the Foreshore and Seabed Act of 2004, and that is clause section 52(2)B, and that basically requires an applicant to hold contiguous title to the foreshore and seabed since 1840 to the present day as a qualification for the granting of customary title. Onto section 160, and that's the burden of proof. And there's a fundamental problem with the Macca cases in the sense that we've got an adversarial process without an adversary. It's a ridiculous situation, and it is much more suited to an inquisitorial approach. And our submission is that that is the approach that the courts should be adopting. Because really you've got a situation where there's only one-sided evidence, and that does not work in an adversarial process. I also believe that section 160 should be amended to expressly exclude hearsay evidence, because from the cases, a lot of it is just hearsay, what went on, passed down from generation to generation without any element of fact.
Okay, now I'm getting mad. We'll stop him there.
Seriously?
Yep.
Wow.
I'm going to be very blunt and quite explicit with my language, but he is fucking wrong. And I'm saying that as a descendant of someone who signed Te Tiriti Iwiko. Okay? And I'm going to quote what the New Archives of New Zealand just have stated on this. Māori have been writing for almost 2 centuries. It is not uncommon for whānau, hapu, and iwi in Māori organisations to have manuscripts and other documents, documentary taonga from 1860 onwards, still in whānau possession. This is especially so for whānau with connections to tribal whare-wānanga, so those at the houses of learning, and maramatanga, or political movements. Okay, so these are the places where you would expect to have records of tikanga in relation to the land. Okay, they knew the importance of writing. My ancestors knew the importance of writing. I've got access to their documents. Okay, I know my whakapapa. I can prove that. You know, it's just, this guy is to say, oh, it's all hearsay because it's all passed down orally. Yeah, it was originally before Māori understood how to write in English or, you know, utilize writing. But my God, they were quick to get onto that shit when they understood how that worked and the importance of it. This guy is just presenting ahistorical, I'm not going to call it facts, ahistorical rubbish. Tūtai. Ahistorical tūtai. And that's my rant.
Oh, let's continue.
The standard of hearsay is well defined in the Evidence Act, and in my view, that's what should be referred to. So hearsay evidence should be specifically excluded from evidence because it is just so unreliable. The final area, and this is of serious concern to me, is the shared exclusivity issue that was simply touched on just a little while ago. You know, to most people, exclusive means one. It means one particular group or one particular person. Churchman in the High Court,
or one iwi, or one
looked through a
waka.
tikanga lens, and he said, it was almost an Orwellian approach in many ways, he said exclusivity can be shared, and he issued jointly held customary marine title. We believe that should be specifically excluded in the legislation, and we submit the bill should prohibit jointly held customary title. But there's another issue that has arisen in the last 2 weeks, and I'm referring here to a minute by Justice Churchman dated the 18th of October, just released last week, and it relates to Ruapuku Island, which is between Bluff and Stewart Island. Now, that is a case that's to be heard in April next year, and there's only a few applicants, but what has happened and what's transpired is those 2 applicants have now proposed to merge their application into a single application, and Judge Churchman looks as though he may be allowing that. And what that would provide is that those 2 applications would be withdrawn and the new application in the name of a new applicant would be submitted. Now, in my view, that's offensive from a couple of points of view. Firstly, it's well out of time. The cut-off date was the 3rd of April 2017. This is 7 years after the fact a new applicant has been introduced.
Was it?
And in my view, it is simply a device to get around the exclusivity rule that has now been tightened up. And it certainly has that effect if it wasn't the intention. And that, I believe, is a matter of serious concern, and it shows that the exclusivity rule should be expressly negated in this legislation, and it should clearly prohibit new applications. I have got no objection to joint applications, but the time to make that application was prior to the 4th of April 2017. It's not 7 years after the fact, once they've seen the writing on the wall. Thank you.
I'm sorry. I'm sorry, but sometimes you don't find out facts until after 2017. I used to be an ACT supporter. I didn't find out the facts about their shitty takes until after 2017. Stuff happens. Sometimes new information comes up.
Yeah.
And why would you persist with an application which you know is not the best application to be hearing?
Exactly. Is it illegal to, I don't know, update an application? Is it?
No, not actually. And it's, I mean, it's basically, that would be like, you know, submitting new relevant information. It's very
That's what I thought.
Process. I mean, that even goes into the case of the courts where you'll have, you know, new information put out that, you know, could happen midway through trial, such as, shall we say, an interview on Fox where Trump admits to the crime and the following day in a trial it could be presented as new evidence.
Yeah, no, I apologize for all the interruptions. It's just this guy just made me really mad in particular because it's just like a lot of it's just
feels
rubbish.
a bit like how what do you call it, the pet interruptions.
Yeah,
except I'm having to hit the pause button
it's
because
like pause.
yeah,
It's like I need a red buzzer.
yeah.
Refrain from commenting on live applications, just as a general rule for committee members. We have run over time. I will, given that we did eat into your time substantially with the first submission, there is a question there from Takutai, so I will put that question, otherwise we will move on.
Kia ora, Frank. I just note that a lot of what you put forward are actually fundamentals and philosophies from the tangata tiriti side of the treaty. Okay, so they're fundamentally tikanga Pākehā views, like exclusive title or shared title should be thrown out because exclusive should mean one. So that notion is not a notion in Te iwi Māori. Okay, so Māori are happy to have multiple ownership, to have multiple use. So my question to you, and that's been a reoccurring theme in both of your presentations. So my question to you, well, actually, I'll just let you know the exclusivity idea with regards to Ruapuke. I'm a descendant of Ruapuke Island, and Ruapuke Island is one family. So it's just, but by virtue of the nature of Pākehā law, those families have been divided into separate camps. So the best way for that family to put their case forward is as one.
Okay, I think we'll move to the question because I don't want to get
so the
too
question
much on
is very
live
simple.
action.
It's very simple. How do you think the new law should give respect to one of the Māori side of the treaty that signed up to the deal? How do you think the new law should give effect to honouring the Māori side of Te Tiriti o Waitangi?
Well, I think it does because it gives people the opportunity to apply for customary marine title. The essence here that we're dealing with, instead of it's about quantum, how much should reasonably go into customary title? The Parliament of the day said anywhere between 4 to 10% around that area. The court's ruling would indicate it's more like 90 to 100%. This is really the essence of what's going on. The right is still recognised. It's about to what degree.
Surely you recognise that
okay. Unfortunately, we will
use their coasts.
No, sorry, we will.
Them.
No, we will be winding this up now. We are significantly over time. So thank you, Mr. Newman, for your submission. We appreciate your time this afternoon. Members, will move on to our submission now from New Zealand Law Society, Kahuri or Aotearoa. Thank you for those comments, Mr.
Okay. God, that was interruption hell.
Sorry about that. You got any thoughts, Chris?
Oh, man. None more advanced than where I was before, which was, what are they so afraid of? I mean, seriously, a decent, solid chat that is evidence-based and historically sound. What are they afraid of?
Oh, it's the evidence that don't suit them. I mean,
Exactly.
in Wellington, they would be part of the anti-cycleway brigade going, hang on there, I don't agree with the evidence, so the evidence is wrong.
Yes, well, Ruapuke apparently was the site of 3 chiefs signing the Te Tiriti o Waitangi. So for something that's just a small speck of an outcrop of an island holds quite some significance.
Yeah.
Okay, head to the Law Society.
Let's see.
Ferris, I will remind members that members did put it to me that we were running over time and that members wanted me to adhere more closely to the order of Parliament, and I did write to them outlining how we would be conducting hearings, including that questions would be succinct, otherwise they won't be put. So we will be sticking to that guidance that was issued on that. So thank you. Can I welcome in Deborah and Lizzie for this afternoon's submission. We have you for 10 minutes before us, so I'll hand over to you to provide your submission.
Kia ora, members of the committee. Thank you very much for hearing this submission today from the New Zealand Law Society. We have really three main points to address, and I hope that we'll be able to answer some questions. I'll speak just very briefly to 2 points, and then Lizzie will follow up. The main issue that I'm going to refer to is issues of principle from a public law and a rule of law perspective, and that the New Zealand Law Society recommends that any changes to Section 58 of the Main Act should await the outcome of the appeal to the Supreme Court, and after carrying out more extensive consultation with Māori. The first issue that I'm going to address is around the inconsistency with the Treaty of Waitangi, and the concern that the Law Society has is that the proposed amendments are inconsistent with the principles of the treaty. Our submission refers to the 2023 Waitangi Tribunal Inquiry report into the Main Act that found that aspects of the Act are inconsistent with the treaty principles, and that the whole Act fails to balance Māori rights against other public and private rights, and recommended that Section 58 be removed without substantial interruption test. But rather than addressing that issue, the proposed amendments seek to revisit the balance and further restrict the expression of Māori customary rights and interests in the Takutai Moana. The Waitangi Tribunal has further reported on the bill and the proposed amendments, and reached the view that the amendments will breach treaty principles and that Māori are likely to suffer prejudice. And the detail of this is in our submission. I think at this point, I'd actually just like to address a question that I heard proposed by, a very important question that I heard proposed by a member of the committee earlier on to a submitter, saying, well, what should we do then? Are you just happy to leave the Act in place? Should it remain intact? And really the Law Society submission around this is that further engagement and consultation is required, that the Supreme Court process should be allowed to run its course, and if changes are required, there should be a comprehensive and extensive consultation process, not a truncated process. The second issue, which I'm going to refer to, is the retrospective effect and the interference with the judicial process, and the significance that this has to rule of law issues. We're looking at issues of comity and balance between the courts and Parliament. Yes, Parliament can make law that overturns decisions and reverses decisions of the court, but the scale, the nature, and the extent of the change, the convention is that this should apply with the least risk of it disturbing the constitutional relationships. There are a range of options that were presented when this bill was being decided, and in fact the most far-reaching option was taken rather than the less drastic option. So the general principle is that it should not interfere with the judicial process currently in place, and should not deprive individuals of the right to benefit from judgments in the proceedings. In this case, applicants who already have proceedings underway are in many cases doubly disadvantaged. They've already incurred costs for litigation and will incur further costs and delay, and there will be a higher test. And again, the issue was raised previously about the more traditional principles and which should apply. There's an example that's been given in many of the papers that led to this legislation about look at how this has been done in other cases, and one of the examples is the Parliamentary Privilege Act, which actually restated the law as Parliament thought it should be. In that case, in fact, the law only applied, new law was to apply prospectively. It did not go back and reach back to previous decisions. And so there are ample examples where the law has overturned results but applied prospectively. I'm going to finish there, and I'm going to let Lizzie deal with some other issues around overriding provisions.
Just to let you know, you're very quiet, Laura.
Oh, I'm just enjoying the palate cleanser. She's absolutely right. The position of the Law Society is in line with what the Waitangi Tribunal found.
All right.
Kia ora, Deborah. Tēnā koutou katoa. I'll speak to part 6 of the submission, which concerns clause 6 of the bill, introducing new sections 9A and B. The Law Society has concerns with both. The high-level concern is that they potentially have significant constitutional and rule of law implications and potentially have wider effect on the application of the Takutai Moana Act than is intended or is necessary or appropriate given the purposes of the amendments. In particular, in respect of the new section 9A, the Society is particularly concerned if the CMT amendments are to prevail over any other law, including the New Zealand Bill of Rights Act and the Treaty of Waitangi Act, effectively making this some kind of supreme law. And we say if, because the intention is not absolutely clear from the text. There is an issue about what is the meaning here and can it be unambiguously interpreted. It's not proportionate to the problem sought to be addressed. It is stated in a machinery provision, and ultimately it's fundamentally contrary to the rule of law. So the submission is that subsections 3 to 5 of that section 9A require further attention. While the Law Society's overriding submission is that the bill should not proceed, if certain law is to be overridden, it should be specifically identified and stated in the legislation. In respect of the new section 9B, the Law Society's view of this is that this section is unnecessary given the stricter section 58 test and amendment to the preamble that is also proposed. It's likely to introduce uncertainty and complexity to the decision making. We are particularly concerned with subsection 3. It raises a much more significant change than is perhaps intended for the amendments to address a court's decision, and that is appropriate given the extremely short engagement and consultation period and the incomplete policy work foundation for these amendments. Its blanket effect is inappropriate because many of the aspects of subsections 4, 6 and 7 of the Takutai Moana Act remain relevant to the consideration of CMT, notwithstanding the proposed changes to section 58 and the preamble. And the reasons why, I won't go into them now, but they are explained further in section 6.9A to C of our submission. And Deborah and I are happy to take any questions. Thank you.
Thank you, Deborah. Thank you, Lizzie. Deborah, a question for you. You made a comment around, questions about the appropriateness of Parliament's perhaps overreach and interfering in the court's processes. Could the same questions and arguments be made around the court's current approach, or the court's approach in, say, Edwards, around the interpretation of 58 as it stood, and whether or not the court exceeded what would be an appropriate level of statutory interpretation?
Thank you very much for that question. In many ways, I think that it's a simple issue about the courts doing their job around interpretation, and where there is an ability for the courts want to find a solution. Not everything is always going to be spelt out in legislation, and so the court has had to resolve something here. Really what we're looking at is this an appropriate way to go forward? If it's not, then surely the answer is to have a detailed consultation process and to have an enduring answer and an enduring solution to it, rather than a very brief consultation and a truncated process.
Thank you. We'll take a question from Dr. Webb and then we'll wrap up.
Kia ora. Excuse me. We've just been talking about retrospectivity, and I really appreciate your submission on that. I may have got it wrong, but you seem to draw quite a bright line. Whereas it strikes me that, all of the claims are now filed, but they're all progressed to different degrees along that timeline. Some have had decisions made, some have had hearings finalised, but decisions reserved. And I guess my question is, given the government isn't going to make it entirely non-retrospective, do you think a line can be drawn where, for example, the case is closed but the decision hasn't been made? Does that make sense? Or are there any other lines that could be drawn in terms of limiting retrospectivity?
Well, the conventional approach has been to draw the line to proceedings commenced before. So the commencement of proceedings before the passing of the legislation. That's what's used, I think it's in Section 16 of the Parliamentary Privilege Act, which that is the way that is fairest, because otherwise how do you differentiate between classes of litigants? And that's really the problem that we have here.
Thank you both. Thank you, Dr. Webb. We will finish our session there. Thank you just on behalf of the committee to the Law Society for providing this.
Okay.
Yeah. The thing about legislative overreach there, retrospective overreach, is in the new Section 9A, subsection 3, it says the CMT amendments, the customary marine title amendments, prevail over any other law. Any other law. It's really quite blanket. So there's no carve-outs, there's no exceptions, there's no specificity, any other law. So there you go. All of a sudden, this is elevated to the top of the pile.
Yeah, it's yeah. I don't know what to say.
No.
Any more good submissions to sit there and follow with? There is, as you put in the notes, Laura, that was the last one.
That was the last for my recommendations. Chris,
okay.
I found one which was a complete cooker, but in terms of time to give to life to give to this, it's no. It's entertainment.
Oh, come on, we can do have a good laugh.
Give me the time.
It does not advance any.
Give me the timestamp in the chat.
Yeah, I'll see if I can. I'll see if I can find it.
But yeah, I do appreciate the Law Societies.
We need some entertainment because cooker material gets views.
It does.
Yeah.
It does. I just chucked in. Oh god. Okay. I just chucked in the Law Society because I needed a palate cleanser.
No, I don't think it's worth it, frankly. If you wanna go finding it, then it's one of the very first ones of the whole in-room committee.
Was it Patrick O'Rourke?
No, 2 or 3 after that one.
Fiona McKenzie.
That's the one. Yeah.
Yes. All right. Okay. I haven't actually watched this one, so.
No, it's not long. It's about 4 minutes. So.
All right.
Yeah, and if you really want it, but no, I do not want my name associated with this in any kind of prejudicial way.
I will cut this one will be cut out of the main one on there. So I'm just waiting for it to load.
And but what's coming is a good demonstration of the mindset which is out there, which is we don't want to talk to our neighbours, let alone anyone else in the world either, because they're all bad.
There's some wacky, wild ideas out there. There's just like,
yeah. And the other thing that I appreciated about the Law Society's response was the recognition that this response, this amendment bill, is out of proportion to the problem they're trying to solve. And I guess that's a feature of this government, is they go big.
Yep.
They just
in
go
the
big.
wrong
They go
direction.
hard. It doesn't. Like I said, they have ideology. It doesn't matter.
Yep.
Okay, I think we have.
Okay, we will move to our submission. Next one is from Fiona McKenzie. Fiona is also going to join us online.
I should have bought popcorn.
And just for your papers, Fiona is the submission for Andrew.
I'll just see if it is this one. Yeah, and we've been doing this for 4 years, these online submissions, and they still haven't got their heads around the tech, eh?
Oh, I would say that, like, put it this way, and it's in the ballot remote connection is much more efficient.
Yeah.
When they turn up.
Maybe we should be the select committee.
Morning, Fiona. If you're
See if we can get the
with us,
contract.
thank you. See you online there. Thank you, Fiona. Hey, good morning. My name is James Megg. I'm the chair of the Justice Committee. Thank you for being with us this morning to speak to your written submission. We do have your written submission in front of us, so please take that as read. We've got 5 minutes with you this morning to speak to that submission. So if you can take us through it, hit your key points and allow some time for questions at the end, we'd appreciate that. But time is yours. So over to you.
Oh.
Thank you, James. I'm a little bit in contrast to your previous submitter in that I do commend the government for taking steps in the right direction with this bill. I won't go through the whole written submission, but I will just focus on my overarching concern with it as it is and with all legislation, to be honest.
She sounds sensible at the moment.
It does not go far enough.
Just
in
wait.
recent decades, I feel that New Zealanders have been badly let down by all those who've been paid to manage our country, and it's going to take a lot of honesty and simplicity to earn back that trust. For us to be reassured that you care about the good of all New Zealanders, I ask 5 things of you. That's all of you, that's government, that's bureaucracy, that's everybody involved. One is that you assertively defend the public interest in all our natural resources. We, the public, must not be left defenceless, unfunded and unheard when favoured groups are publicly funded to claim the birthright of New Zealanders, and this has certainly happened in the MACA legislation. Secondly, that you ensure that we are all equal before the law, no matter who our ancestry might include or exclude or partly include even. 3, that you ensure the law incorporates transparency, accountability, and limits on anyone's power. That's something that's concerned me greatly with a lot of the legislation that's gone through, that there are just no safety nets to undo things when people abuse power. And no matter which group has control, there will always be abuse. Humans are flawed, and we must prepare for the worst and hope for the best. To that end, all
Don't get me started on
legislation
climate
must
change
be
with that point.
certain, easy to understand and be knowable by ordinary New Zealanders. Those essential requirements certainly rule out tikanga, waitapu, compulsory iwi approvals and unspecified koha, and the now out of context 1840 Treaty of Waitangi. Sorry,
Yes,
Willie,
good
but
stuff.
they are unknown by New Zealanders and they're just unfair. The treaty was a wonderful document for its time, but it simply cannot be reinterpreted and reapplied to our blended people totally out of context and in our democracy. In 2024, the Treaty of 1840 is totally redundant. 4, my 5th point,
She's
fourth
got
point,
big ones.
is that common sense and understanding of psychology and how people will react, or how groups of people will react, and the long-term good of all is inherent in any laws you pass. And if you worry about how the separatists will react, well, we have all seen and heard in recent years that they will never be satisfied until our country is destroyed.
Holy moly!
And my fifth request is that you appreciate New Zealand's uniqueness. We must not be subjugated by the UN.
We must appreciate the
which is
uniqueness
very much a
by being
failing
like everyone else.
organisation. We cannot be beholden to the UN's diverse and not always pleasant membership, or some of its ridiculous dictates that have no relevance to our country and our people and our history. Many of those only serve to undermine our democracy and our social cohesion. In 2024, Queen Victoria does not rule her empire. Tribes do not.
Just to let you know, in 2024, the sovereign was King Charles III, the great grandson of Queen Victoria, who unfortunately would have been dead by about 120 years.
Yes.
Dominate their domains with spears and muskets. and those with Maori ancestry are certainly not a group apart and share ancestry with all of us. And most New Zealanders want a future of unity, peace and prosperity, not division, not resentment or worse, which I'm very, very concerned about for the future of this country. So my final request is please do the sensible thing for all New Zealanders, no matter our bloodlines, how rich or politically powerful we are, or what the separatists and extremists demand. To ensure First World Government of New Zealand and all its peoples, the Crown must resume ownership of the foreshore and seabed for the benefit of all New Zealanders, as it did under Labour's 2004 Foreshore and Seabed Act. And that's all I have to say. Thank you.
Thank you, Fiona. That is bang on 5 minutes. So
there we go.
We'll leave it there. So thank you for your submission.
Gee, her filibustering evaded her from being able to sit there and get questions. But oh my God, like she physically is in 2024 using technology of 2024. She is mentally, I would have no clue where the hell she considers herself. I mean, it is probably post 1893 where women got the right to vote.
Oh my God, I don't even want to know what her Facebook search history looks like. That's just wild.
But you
wow.
see, you found a Facebook page. I mean, for me, that because I ran across this one and I thought, oh yeah, okay, hang on. Trigger warning. Trigger warning.
Yeah.
Trigger warning. And she has the balls, to put this into a New Zealand Parliamentary Select Committee on a topic which is all about trying to find a way through without completely buggering a relationship with a treaty partner. And it's like, oh my, I mean, who's listening? Because somebody's listening to people like her.
Someone gave this the green light. Someone looked at her submission and said, "Yeah, we need to hear from her orally."
Well, no.
I want to know who was responsible for that.
No, when it does come to submissions, you can select whether you want to submit orally or not.
Yes.
They do not sit down there and go through going, "We want to hear from you." Now, if you they do make contact with you. Can you please present this orally? If there's something that's unique or something to it, but generally speaking, you can go tick the box. I would like to present orally.
Okay, all right. So
to me, this there's so much wrapped up in her submission. So much wrapped up in her submission. When she starts talking about lack of trust in the media, well, lack of trust being generated in the media is kind of, proto-fascist behavior. And then she wants to talk about the uniqueness of New Zealand by completely ignoring the uniqueness of New Zealand, by wanting to trash the ability of the uniqueness to have some, meaningful expression in our civic and legislative lives. I mean, it's like...
What gets me, she talks about
cognitive dissonance.
Yeah, she talks about government abuses. And she's like, we need to make sure that the government doesn't abuse people, but at the same time, it's okay for the government to abuse people. I'm like, what?
Yep.
Oh, okay.
So the select committee sat there and listened to it.
Yeah. No, Sam Summers and the members of It's in the Ballot, you cannot do any crowdfunding whatsoever because I'm the arbiter of crowdfunding and you can sit there and do it. Oh, I didn't realise your annual income of 4 members of your team was collectively less than my councillor's salary, but you know what? My rule still applies. And that standard was set by then Councillor Tamatha Paul before she became an MP.
Oh.
Yep. And according to some of her supporters, me calling her a hypocrite for that standard is racist, missing the point of why I have regarded her as a hypocrite.
Oh.
Huh.
Yeah, just for those who are wondering, that Tamatha and I do not have a particularly conducive working relationship. However, every other Green MP that I've dealt with, I have no problems with.
I'm wiping the sweat off my brow as I'm hearing that.
Yeah.
Yes. Julian Gentle, my local MP, is absolutely great to deal with. Now, before we go, this is such satisfying news. Now, anyone knows I have an absolute passion to hate wins. However, it is unusual to see that the MSD have gone to the police to obtain a restraining order over $2 million worth of fraud. Now, I want to know, was this fraud obtained by beneficiaries having to apply for recoverable assistance? Because if that's the case, this is pretty damn concerning, considering from what reading on here was that the theft was associated with being a supplier to MSD grants for basic household items. And it would be where people apply for advances for things like chairs, tables, fridges, washing machines, that sort of thing there that you can get from MSD. Now, the question that hasn't come up in here is whether it was done by people having to pay recoverable grants. And if you get a payment that is recoverable, you tend to usually pay that out of your benefit each week until the debt is paid off. So that's it's the first time I've actually seen MSD actually take that seriously, because when you've had a situations of a dispute where MSD has provided a grant to pay for it, they usually tend to wipe their hands of it. They don't tend to usually go through and ask the police to use the Criminal Proceeds Act, considering most of the time the police tend to tell MSD to piss off, because MSD produces cases that often don't end up having this, that the police just would not touch. So if that gives an idea. So I'm really surprised by that, but this does feel a bit satisfying that for a change, MSD are actually going after anyone other than beneficiaries, who are often defenceless and would sit there and potentially believe, was it based on what we consider and do? On the fraud debt here, we estimated you committed $40,000 worth of fraud per year every year, while the amount you got paid on a benefit was less than 20 grand. And that's a common thing they've gone after people for, saying, so, it's good in this particular case, they're going after it. Now, it is $2 million. Most fraud stuff that MSD tend to go after is usually less than $100,000. And that's before it actually properly gets worked out and actually checked properly. And I do remember one case, an $80,000 fraud case that led to the woman committing suicide, actually ended up that no fraud was committed after 4 revaluations of the so-called debt.
Why is
I don't know about that, McGregor, about the benefit bashing rhetoric. It will probably sit down there and probably go, the beneficiaries were stupid to go to that particular place, even though MSD actually forces you to go to certain suppliers. And I can tell you right now, it's not exactly easy to actually become a supplier of MSD. Your business either has to be GST registered, except if you're a landlord. So if that tells you something, it's not quite an easy process. But yeah, and I mean, how many people have had to pay off debts associated with those with advances that possibly never arrived? That's the only thing I can think of as the reason why they've got to that point there. Because, if you received a product that was charged twice the going rate, MSD would just go, yeah, it's not our problem. Even that they usually tell you to go for the cheapest price quote possible. It's it's quite weird how if it's not that, and it's not Labour's fault. It's criminal, regardless of who's in power. Yeah. Okay, so let's get to the interesting part about the bills that are coming up for submissions. Oh, no, cheeky comment. If you want me to deliver fruit and vegetables to your house in Wellington, you've got till 9 p.m. tomorrow to place your fruit and vegetable order. Now, back to the serious topics. Let's get up there. There's the Parliament bill that you want to put in a submission. You've got until this Wednesday to get your submissions in on the Parliament bill. The Buildings Overseas Product Standards and Certification Schemes Amendment Bill that is due on Thursday, the 14th of November. Get your submissions in. The Dairy Industry Restructure Export License Allocation Amendment Bill. You've got to the 17th of November to get in your submissions. And the Budapest Convention and Related Matters Legislation Amendment Bill, you've got to the 28th of November to get in your submissions.
Which is actually far more interesting than that rather dry title suggests.
Yeah, that looks really interesting.
Actually, you probably, since it's more interesting than what the title says, what is it? Is it a
It's
treaty?
about normalising New Zealand's legislation with the requirements of the Council of Europe's Convention on Cybercrime, which is also known as the Budapest Convention.
Ah.
So yeah, it's about so it would do all sorts of things with our own internal surveillance and other criminal matters legislation that we've had in this country and bring it up to date so that it can deal with cybercrime and keep us in good stead with the Euros.
Ah,
Because
okay.
there might be other things like trade deals on the line for this.
Yeah.
God, for all these things you find that are so interesting that we wouldn't even... like, I was just thinking, what the hell was that bill? Was it a sanctions bill? I didn't know. It was just like, yeah. But that's actually quite interesting that you've helped widen our minds for tonight.
Yeah, so that one's definitely worth a closer look, I reckon, for those of you who have an interest in cybercrime and international kind of obligations.
Yeah.
Very interesting, that one.
Yes.
The dairy industry one looks very technical.
Yeah, it does.
No, I'm not getting into that one. But the Parliament bill actually looks very sensible. And I was looking at the debate, and it's quite interesting when all the parties in Parliament stand up and say, "Yep, we're into this one."
Did you watch our version of the debates?
No, I looked at the actual Hansard Vimeos.
Oh no, we did a whole show dedicated to it.
Yeah, no, I didn't look at that. So
No. We did a whole show dedicated to it. We did an urgency special. It's what happens when there's a busy week in Parliament that there's so much that has been done, but there's not enough time to cover in a 2-hour show. We do a special one usually at 3 p.m. on a Sunday.
Right.
And that was an urgency special. We focused on it, considering I consider it as a bill that is actually, we kind of needed to know shit, but it did not meet the polling, because we poll out the bills to cover when there's actually a good selection to do, and they didn't sit there and, there was nothing to poll out for it.
Well, no, and I suspect that's because it's entirely uncontroversial.
Yeah.
Very sensible legislation.
The bill was just called the Parliament Bill, so that's part of the reason why it's possibly gone on there. Okay, so thank you for joining. For our panelists who wanted to join post-show chats, feel free to stay online. But for those who are watching, you'll see us planning to be back at 8 p.m. next Sunday. And hopefully the house doesn't go into urgency between now and then, because next week we can have an urgency special. But if we have one the following week, you're going to have to run it, Laura, because I will be selling coffee at Lower Bay School.
Happy to do so.
Yeah. Have a good evening.
Yeah.
Thank you for watching the Order Paper, your express ticket to the New Zealand House of Representatives. Every episode, we unravel the complex world of legislation, debate, and democracy. From bills to select committees, we've got it all covered. From our team of political commentators who will dissect and explain what's happened, so you can remain up to date on what's happened in the Aotearoa, New Zealand Parliament. To support our channel, you can become a Patreon member at patreon.com/It's in the Ballot. The Order Paper podcast is brought to you by It's in the Ballot Productions.